All right, the court is calling 2023 CR 1876, State of Texas versus Yvette Martinez. Now parties announced for the record for the state.
Jason Gearhand for the state, Your Honor.
Defense.
Lawmaker for Ms. Martinez.
No contest is basically saying, I won't fight you, but I'm not admitting guilt either. It saves facing court and avoids the word guilty sticking to your record, at least for now. But remember, the consequences can hit just as hard as a guilty.
Are you Yvette Martinez?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. All right. State, are you proceeding on the indictment as presented?
No, we're waiving count 2, Your Honor. Proceeding on count 1 alone.
Any objection?
Not, Your Honor.
Did you understand that you're charged with intoxication assault as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? Court could find you guilty, sentence you up to 10 years in prison and an up to $10,000 fine.
Yes.
Counsel, has your client been able to provide you with any defenses?
Did you catch that? Intoxication assault is a third degree felony That's serious business. Minimum 2 years, maximum 10. Imagine rolling the dice on your freedom every time you step behind the wheel after drinking.
She has indeed.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
According to the plea bargaining agreement, state is proceeding on count 1. They're asking your punishment be assessed at 10 years in the prison. There's a $2,500 fine. State opposes your application for deferred adjudication. They recommend community supervision. There's to be restitution, if any, to Julio Casas Jr. and Cameron Casas. Also, you are to stipulate that on or about January 7, 2022, you were at Pockets, a billiards bar and restaurant located at 5819 Northwest Loop 410, San Antonio, Texas, 78.
Part is crucial, folks. She admits she was drinking, driving, and caused a crash. That admission locks the case in tight. There's no wiggle room left. What do you think? Should a full-on guilty plea come with harsher punishment, or does remorse deserve leniency?
238, where you were drinking alcohol beverages and only consumed alcohol beverages at that location, then left the location driving your vehicle, and you drove your vehicle into a vehicle occupied by Julio Casas Jr. and Cameron Casas. Did you understand that to be the plea bargaining agreement?
Yes.
Defense?
We did.
State?
It is, Your Honor.
State is requesting that your community supervision be for a term of 10 years. There'll be a TAP evaluation, 200 hours of community service restitution, ignition interlock for half the term of probation, and 2-year Texas driver's license suspension. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged in count 1, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, Your Honor. State exhibit number 1 with all its attachments.
No objection, Judge.
All right, and Norma, I'll need a date for PSI. And probation is going to be a PSI and TAP. And state, you may be excused. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. I'm going to request a PSI and TAP evaluation, and you will be back here on August 3rd. At that time, I will make a decision on your application based upon the PSI report and any other evidence that's submitted. You understand?
Yes.
We can go off the record. So is she on any type of device?
I like monitoring.
I'd like to monitor, Judge.
All right. Thank you. Probation will let you know what you need to do, and Ms. Ferguson will give you a reset.
Your Honor, does that leg monitor need to remain until August the 3rd?
Oh, yes. Okay. All right. Is there anything else?
Nothing further from us, Judge.
All right.
Thank you.
You're welcome.
I just want to tell you that I feel awfully bad for what I've done. I am sorry, Your Honor, and I learned from my mistakes. I would never do this again. This is embarrassing, and I have two kids and I want to be the life for them and I just,
Okay, what I will tell you
I'm
is.
sorry, that's all.
No. What I will tell you is this, and I think these are not mistakes. These are choices that people made.
Yes.
So it's a bad choice that you've made, but it's not a mistake. Okay.
I
All
meant
right.
to say the choice, yes.
All right. No problem. I understand. Thank you.